Your Honors, this case is...
Would you like to reserve any rebuttal time?
3 minutes, please.
Excuse me?
3 minutes.
3 minutes, all right. You may proceed.
Thank you, Your Honor. This case is on appeal from a termination proceeding, and the underlying dependency and neglect case involved the removal of the child by the Department of Children's Services. So at trial, the trial court found several grounds to support the termination, as well as that it was in the child's best interest. So this matter has been thoroughly briefed already. I will try to hit the high points on the grounds that were found specifically, as well as the best interest. The first ground was clear and convincing evidence of incarcerated parent and wanton disregard. We believe that the nature of the appellant's conduct does not meet the level of wanton disregard, in that any pattern that could be shown, some of that criminal conduct happened well before the life of the child and before he knew of the child. And the initial criminal conduct that stemmed to his ultimate incarceration occurred February 2nd of 2019, which was 5 months before the removal. And it was ultimately a full revocation of those initial charges that led him to the TDOC sentence of 3 years to be served at 30%, which he ultimately flattened and was released. And that was voluntarily pled.
He is out today?
He is present, Your Honor, yes. The second ground that was found was failure to support. Now, preliminarily, the appellee has argued in brief that the appellant did not properly assert that his defense of it being willful. We respectfully disagree and would assert that his testimony at trial, he affirmatively asserted that it was not willful. And based on that, he was employed at a halfway house working at a paper company during the applicable time period, where he was paid hourly. Out of that hourly salary, part of it was placed into a savings account, it was called, which he had no access to until he was to be released from the halfway house. And the remainder went to food, housing board, as well as he was being garnished for criminal fines and fees out of the previous criminal action. He testified at trial that after all that was taken out of his paycheck, he had between $45 and $100 a week left. He also testified that he gave support to the child's mother prior to removal, and the record is clear that at no point in time was he under a child support obligation, nor did he have any knowledge of where to send any child support during the proceedings. There is a theme to all of this, and is that there was poor communication between the appellant and the department.
Is this one of those situations where you have to, in your answer, say that this was not willful, or is this?
The court has made the determination that it can be pled as an affirmative defense in the answer, but alternatively it can be.
The trial court in this case? It
can be raised in the trial court, yes, through testimony.
I mean, did you raise it as an answer, in your answer, that?
It was not brought by answer. Mr. Sykes testified to it at trial.
Okay, was it objected to?
Not that I recall.
Okay, so by consent it was raised then?
I believe that's accurate. Okay. I do not recall that it was objected to.
Okay.
So our argument is that even if Mr. Sykes had money at the time, he didn't know where to send it, didn't know what the amounts were. The prior orders of the court, which he had not been properly brought into at this point in time, did not address child support, and there was not a child support order rendered by the district attorney's office until December of 2019, which ordered him to begin support payments on January 1st of 2020, which is outside the applicable time period applied by the trial court.
You realize that in termination cases, there's no necessity to have a court order setting child support.
That is correct, Your Honor.
To pay support.
And he acknowledged through his testimony that he was aware of his duty to support the child. We're merely arguing that he had no idea how, where, when, frequency, amounts to send that child support to during this period of time. And the nature of this appeal underlying it all is that The child was removed in July of 2019. The department knew where Mr. Sykes was. They knew where he worked. They made no efforts to afford him due process and perfect service on him, despite knowledge of his whereabouts.
Wasn't there a reason for that, or a suggested reason anyway? That being, was he incarcerated at the time?
He was in a halfway house in Memphis. He was free.
Okay.
Um,
And obviously, it would have been better if he'd received notice of that, but was
That's
there an
correct, Your Honor.
obligation to provide him notice?
And that was later remedied once he was finally afforded his right to counsel. His counsel filed a motion to set aside the actions of the court, which was done. And then a second dispositional hearing was held at a later time. It was at that point that he was incarcerated, and 4 months after the dispositional order was entered, the petition for termination was filed. So during all that period of time where he was not properly before the court, part of the case, you know, he didn't know what he was supposed to be doing, how he was supposed to be doing it. He did not have counsel. There's no proof on the record of exactly when.
Was he aware of any of what was going on?
He was made
Or is
aware.
there any proof in the record about that?
There's testimony that he was made aware that the worker contacted him after the removal at the halfway house, but there's nothing in the record that he was ever properly served, notified, anything along those lines. And in fact, as far as the ground for failure to manifest goes, I've cited a case in my brief, in Re Trinity H, which the court stated, in situations where noncompliance with the permanency plan is neither alleged nor found, quote, father is pushing on an open door. In fact, in this case, the department voluntarily dismissed the pled ground of noncompliance with the permanency plan, presumably because they knew the evidence to be presented would not support that the appellant was involved in the creation of any permanency plans, CFTMs, or provided copies of any plans so developed. As to persistent conditions, the court also found that ground. I have briefed and pled the case in Re Elijah R., which I believe is on point, and the appellee chosen not to defend. So I would submit the argument on that ground on brief. And as to the failure to support, the ground for failure to visit was also pled, and the trial court determined that due to Mr. Sykes requesting visitation in July of 2019 and the department's inability to set visitation up until November of 2019, that he had not simply willfully failed to visit. So my argument is that, similar to the court's finding for failure to willfully visit, if he couldn't willfully visit because the department was not making proper accommodations, how could he willfully fail to support if the facts are the similar between the two issues?
But we know from the facts at one point he accumulated in excess of $3,000, and he was aware that he had a child, and he failed to pay any of that money for the support of his child. Isn't that right?
That's correct, Your Honor. To my knowledge, the savings account that he had accrued while he was at the halfway house was distributed to him when he left the halfway house.
And he paid none of that for the support of his child?
Not to my knowledge. The only payment that was made was through an IRS tax intercept based on his joint tax return between himself and his wife for that calendar year. And I believe his testimony was that he used the money from his savings account while he was at the halfway house to contribute to the down payment to purchase a house once he was out with his wife. And that goes to the best interest. The court found that respondents failed to take advantage of the programs offered by DCS and the court. The record shows that there were no programs or services offered by DCS or the court because he was not properly before the court until over a year after the removal. He was not afforded due process. He did not get to participate in any CFTMs or developments of permanency plans. The record is unclear of whether or not he was notified of what his action steps were to be and what services could be offered to take care of that.
It's not clear to me. What order was entered after the second dispositional
The second disposition came about where he did not contest the merits because the only allegation from the underlying dependency and neglect case against him was that he was not a proper placement at the time due to being in a halfway house. The removal was not from him, which goes to the persistent conditions.
So after the second dispositional hearing, the trial court found dependence and neglect as to your client?
Yes,
Is that right?
no severe abuse finding. That's correct.
Okay.
And at that time, he was incarcerated, so he was not in a position to argue the matter of disposition.
Okay.
As to him not having a significant bond with the child, it's true that he was incarcerated, but it's also true that DCS only accommodated 2 supervised visits during the entire pendency of the case. He exercised the first one, which went well. The case summary report is in the record, and he had to cancel the second visit that was set up the following week due to transportation issues. To my knowledge and from the record, there were no further visitations set after December of 2019.
Were there requests made?
As far as I know, he had requested the second visit to be set up. I'm not sure what happened after that.
Okay, so what we know is there was a visit, there was a second visit scheduled. Your client needed to cancel it because of transportation issues, but the record is silent as to any other requests for visitation?
He was incarcerated shortly thereafter.
Okay, got you.
In summary, Your Honors, this is a situation where in Re Brylan S, the court opined, quote, lack of reasonable efforts may weigh heavily enough to persuade the trial court that termination of the parent's rights is not in the best interest of the subject child. If the facts of this case don't apply to that exception in that ruling, I don't know if there's a case that ever would. The department knew that Mr. Sykes was the father of this child. They knew where he lived. They knew where he worked. They made no effort to protect his rights to due process. They made no attempts to serve him personally, no attempts to serve him by publication, no proof that he was provided copies of the permanency plans or his action steps, no proof of when he was afforded the criteria for termination and explained that and signed an acknowledgement, no attempt to protect his rights to an attorney, no proof of any services offered, set up, or submitted to their fiscal department, and there was over a 4-month delay between his first request for visitation and when it was actually accommodated.
Now, your client was there for the birth of the child and signed the birth certificate, is
Correct.
that right? Did he sign a voluntary acknowledgement of paternity?
I don't believe so.
Okay.
All right, thank you, sir.
Thank you, Your Honor.
You have your rebuttal time. Are you splitting your argument, or will you be using all the 15 minutes?
The guardian ad litem, Ms. Stewart, has requested 2 minutes of our time, so I will be splitting it with her.
2 minutes?
Yes, Your
Okay,
Honor.
So you're going to use 13 minutes?
Yes, Your Honor.
Okay. All right. We just need to set the timer appropriate.
Sure, thank you. May it please the court, good morning, Your Honors. My name is Erica Haber. I'm from the Attorney General's office, and I represent the Department of Children's Services in this appeal. This case is about a 3-year-old child who had been in foster care for 2 years and deserves permanency. The McNairy County Juvenile Court terminated father's parental rights. The juvenile court's decision should be affirmed for 2 reasons. First, there are 3 alternative grounds for termination that were established at trial by clear and convincing evidence. Second, terminating father's rights is in the best interest of this child. I will now turn to the 3 grounds. First is the abandonment failure to support ground. As this court noted just with Appellant's argument, father never made a voluntary support to Brylan. Not one time. He was aware of his duty to support the child. He testified to this at trial, and he was given the criteria and procedures for termination of parental rights in 2019. Father was working during the applicable statutory period at a paper company and had saved at least $3,100 in savings. However, father gave the savings to his wife, not to the child. This ground should be upheld. The second ground is wanton disregard, abandonment by wanton disregard. Father abandoned the child by exhibiting wanton disregard for the child's welfare prior to his incarceration in March 2020. Father's conduct during the brief periods that he was out of jail after Brylan was born included that he abused methamphetamine. He chose to leave, he was in rehabilitation when Brylan was born. However, he chose to leave rehab in August 2018 when Brylan was just 2 months old. And as a result of that choice, he was sent back to jail until December 2018. When he was released in December 2018, Father began using methamphetamine again until approximately May 2019. Between that 5-month period, he was arrested again on charges of possession of methamphetamine, felony evading arrest, driving with a suspended license, and others. He then violated probation at least twice. One in December 2019. His probation was revoked and he was sentenced to community corrections. So he was given a second chance to stay out of jail and to work toward regaining custody of Brylan. However, he violated probation again 3 months later. Father admitted to violating probation at that time and was sent back to jail to serve his entire 3-year sentence. As we already discussed, Father also failed to support Brylan when he was out of jail. He failed to maintain regular contact with DCS, and there's testimony in the record that instead of calling DCS, he relied on the child's mother for information about Brylan. Child's mother was also a methamphetamine addict, and she had surrendered her rights to the child. Father failed to attend the first child and family team meeting, even though the DCS caseworker had notified him of same. And to Appellant's point that Father did not have proper notice and due process, Father did have proper notice of the cases. The trial court found that he had proper notice, but that he had not been properly served. So after the first dependency and neglect adjudication hearing, the court, Father did not challenge the adjudication of dependency and neglect, but challenged the disposition. The court then held a second dispositional hearing where the child was still found to be dependent and neglected, and the court found that custody should remain with DCS at that time. Father, when he was released, when he left rehab in November of 2019, he got arrested again, that time for assault. He also married his now wife, but he did not inform DCS of the marriage. He only visited with Brylan once after Brylan was removed from custody, and that was in November of 2019. He has not seen his child since that time. He was also denied parole twice during his incarceration. The record is clear that Father is not able to refrain from criminal conduct or using drugs when he is not incarcerated. This broader pattern of conduct that resulted in his incarceration renders Father unfit to parent Brylan and poses a substantial risk of harm to Brylan. This wanton disregard ground should be upheld. The final ground is failure to manifest an ability and willingness to assume custody of the child. Father failed to manifest an ability and willingness to assume custody. Father concedes that he failed to manifest an ability. So the first element of this ground is met. The second ground is placing the child in the parent's legal custody would pose a risk of substantial harm to the physical or psychological welfare of the child. Placing Brylan in Father's custody would pose a substantial risk of harm to Brylan. As just discussed, Father continued his criminal activity. He voluntarily left rehab after he knew that Brylan was in foster care, which he also knew would send him back to jail. He violated probation twice, again, ending up back in jail instead of working toward reunification. Father testified at trial that while he was making progress in jail and he had found a place to live with his then now wife, and that he was trying to take classes, he did not have a treatment plan for his methamphetamine addiction upon release. He testified that he would go to treatment if required, but instead, if he was not required, he was going to rely on his faith to keep him sober. Father also testified that he had no child care plan in place for Brylan. So while he had a job lined up upon his release, neither he nor his wife had discussed who would take care of Brylan. Father's a near stranger to Brylan. He's only met him a handful of times when Brylan was very young. Brylan is bonded with his foster family and thriving in the foster home, and the foster parents wish to adopt Brylan. The failure to manifest an ability and willingness ground should be upheld. I will now highlight some of the key factors that support the trial court's finding that it is in the child's best interest for father's parental rights to be terminated.
Let me ask you, in connection with the persistence of condition ground, which you're not defending,
Correct, Your Honor.
and the basis of that is what?
Because the child was not in the father's legal or physical custody at the time of removal.
Okay. In fact, if father only signs the birth certificate, is he considered to be a legal father by signing the birth certificate without having signed a VAT?
Your Honor, I don't know the answer to that question.
All right. A father where the birth is not due to a marriage, does a father have any custodial rights without a court order?
I believe so, Your Honor. The marriage was out of wedlock, but because he did not contest paternity, I believe that and the department also did a search to determine whether there were any other fathers challenging paternity, and there were not.
Okay, but let me just make sure I understand your argument.
Sure.
Is that you don't defend the persistence of condition because the child was never in his custody, is that
That's,
right?
at that time, that's right. And so.
Never in his custody at any time?
Right, never in his custody at any time. That's
Okay.
correct, Your Honor. However, he knew of the child's existence. He was present at the birth at the hospital, so he knew about Brylan.
Okay,
And did visit, I believe he visited with the mother before DCS became involved. He visited the child with the mother on about 6 occasions prior to DCS's involvement when the child was an infant. So he was aware of the child's existence.
okay.
Turning to the best interest factors, as discussed, father has not made an adjustment of circumstances or conduct to make it safe for the child to live in his home. He continued to use methamphetamine and engage in criminal conduct even after he learned Brylan was in foster care. And instead of completing rehabilitation and trying to better himself, he chose to leave at the risk of being sent back to jail and at the risk of not being able to reunify with his child. At the time of trial, father had no job and no suitable housing, nor did he have a plan for treating his methamphetamine addiction when he was released from jail. Father argues that DCS did not make reasonable efforts in this case. And while we argue that DCS did in fact make reasonable efforts, and the trial court did find that on several occasions, I refer the court to the record. Exhibits 21, 25, 28, and 29 all have trial court findings where DCS made reasonable efforts. That is just but one factor to be weighed in the best interest analysis. And the other factors weigh heavily in favor of termination. Father lacks a relationship with Brylan, as we've discussed, and changing caretakers and environment would likely have a detrimental effect on this child, who's been in the same foster home since he was 13 months old. We're now working on 3 years with the same foster family, who he's extremely bonded and attached to. This child needs and deserves permanency. Delaying that permanency is not in his best interests. For these reasons, this court should uphold the trial court's termination of father's parental rights. And unless there are any questions, I'll yield the rest of my time to Ms. Stewart.
Thank you.
Thank you.
I believe we have 2 minutes reserved for you.
Good morning, Your Honor.
Good morning.
My name is Melissa Stewart. I'm the guardian ad litem for the minor child in this case. I would just join in with the state's argument as far as the grounds, and I'm going to limit my statements just to the enumerated factors as to best interest. Starting with whether or not Mr. Sykes made a lasting adjustment to his circumstances. At the time of Brylan's birth, Mr. Sykes was in a rehab. At the time of the DCS removal, he was in a halfway house. And at the time of the TPR trial, he was in jail. So I would submit that he had not made any adjustment to his circumstances. And in fact, they had gotten worse instead of better. One of the other factors of best interest is whether the parent has maintained regular visits with the child. Testimony from the trial court would show that Mr. Sykes was present at the birth, that the mother brought the child to the rehab facility 4 to 5 times while he was there. Following that, the only visit that he had was in November of 2019, which was the one supervised visit while the child was in foster care. So a total of 6 to 7 times in the child's 3 years of life. As far as maintaining a meaningful relationship with Brylan, I think that was impossible for Mr. Sykes to do. While he was in the halfway house, he would call his soon-to-be wife on a daily basis. He never reached out and called his son. Following his, when he left the safe harbor, the halfway house, he went to Florida to get married to his now wife, but he couldn't manage transportation to that second supervised visit, which was in the same time frame. He gave $3,000 to his wife that he had saved. Not a penny of that went to his son or to his son's care. Out of the 1,206 days that Brylan was alive as of the date of our trial, Mr. Sykes had been in jail 826 of those days. And in addition to that, he had been in a rehab and a halfway house the majority of the remaining time. Brylan is bonded to his foster family. He's been in the same home since removal. He's stable there. He's thriving. He's bonded with the parents. He's bonded with the siblings, and they intend to adopt. And I would ask this honorable court to uphold the trial court's ruling and allow Brylan to remain there with his forever family.
Thank you. All right, counsel, I believe you've got 3 minutes.
Your Honors, I would address the failure to manifest. It's true this child's been in foster care for 2 years. The only testimony for a risk of substantial harm was made by 2 biased witnesses that had vested interests in the termination proceeding being successful so the adoption could proceed. There's no expert testimony, and it's factually true that long-term removed children are reintegrated back into homes on a regular basis if the facts don't fit like they do in this case. As to the adjustment of circumstances.
We don't really require expert testimony, though, do we?
Not usually, Your Honor. As to the adjustment of circumstances, Mr. Sykes resolved his criminal issues. It just resulted in an effective flattening of his sentence, which he was not expecting due to 2 parole denials. The second parole denial, the actual parole board, all 3 members recommended his release, which was then overruled when the decision was made. He testified that he had a job lined up, that he had a home. All of those ended up being true. He's clean and sober, spent 3 years in jail getting clean and sober. For a treatment plan, Mr. Sykes would have been in compliance with any alcohol and drug assessment, mental health assessment that would have been required upon release, but the case had already progressed past that point by the time that he was released from jail from the effective flattening of his sentence. As to the failure to support, it's true that he had some money in that savings account, and he made the decision when he left rehab to apply that money to try to remedy his conditions and help his new wife buy a home where they would have a stable environment for the child. And it's true that he did not make any voluntary payments, but again, at that point in time, he did not know where to send it, how much to send, and, you know, who the foster parents were. And I'll leave you with this, Your Honors. If the department can't be held to make sure that a respondent is adequately served with due process when they're interfering with their parental rights, is it unreasonable to believe that they would then not follow up with any reasonable efforts after the fact for a case that lasted for several years, including the termination, which has led us to this point?
Thank you. Thank you, counsel. We appreciate your argument. We will take this matter under advisement and will attempt to render an opinion at the earliest possible time. Again, we thank you for your argument. Ms. Angie, if you would recess court to the call of the docket this afternoon, please.
All rise.